Ati for Akroma Daily Update TV message and our channel so hit the man subscribe or send me the latest news to be obeje bre na wansa akabi na ye bora ensem ni mu a wo hwe tokono ensem na Chief Justice enipa bu ha umse ompa asumdwe meka efuagate mo ya ma sese no ye hu se mu wo ase judiciary ne ya kwaye political BS MPP fo nko an ye gum because we enkenfa mo ho emfa mo ho chaloto say tama na ye yi na free so ye hu GBA se mo ba bonten ebe make statement bia na esi dai na efuagate timi ba bonten ede insembe tutu dwa say the impeachment process now, the removal of the Chief Justice now, say ama say no it is the Tameklo so dear momoni to lawyer in penny say mame no wakasa no yes wakasa no was it drew baby na when ya nye di no for nancy forma obi ebetu afa so ye mongram na yentie nsam ni bi ye ba de aka no ye de mu nsam bebremo
verdict of the Ghana Bar Association lawyer to Tameklo.
Okay, so first of all, I need to say that I disagree forcefully with my association president. But you see, the Ghana Bar Association, if you look at its intervention historically, maybe it takes a lukewarm attitude when it's within certain regime, and certainly finds its possible voice in certain other regime. And I'll start with this. If you recall, under President Rawlings, we had a justice of the Supreme Court called Abba. Now what happened was that the Ghana Bar Association had very strong views of Justice Abba. And in order to trigger the provisions of Article 146, which requires that the removal of justices of the Superior Court should be on grounds of stated misbehavior, on grounds of infirmity, unable to perform their function, among others, the Ghana Bar Association decided to use the instrument of a writ action. Now, when the matter came up for hearing, and it was actually adjudicated, incidentally, His Lordship Justice Kwega, His Lordship Justice Ajabin and Co. Had this to say, and let me go back and read. Let me even go back and read quite the reasoning of the Supreme Court when the Ghana Bar Association decided to use an unconstitutional means to get a Supreme Court judge removed. And I don't know how President Mrs. Efuagate would describe that, whether a bad precedent or not. Now, when the issue came up, the Supreme Court, speaking through His Lordship, Justice Ejabin, had this to say. Can I read it?
Yes. Yes, you can.
That's the Ghana Bar Association versus Attorney General and another, 1995-1996, One Ghana Law Report at page 598, quote, "It is clear from the above that under our Constitution 1992, a Chief Justice or a Justice of the Superior Court or Chair of the Regional Tribunal can only be removed from the office by the President acting on the recommendation of the committee appointed by the President or the Chief Justice, as the case may be, to inquire into a petition sent to the President alleging some misbehavior or incompetence against the one concerned." It proceeds. "It is important to note that Article 1468 of the Constitution 1992 provides that the proceedings of the committee appointed to deal with such petition shall be held in camera. It is mandatory. Said that proceedings held in camera, not in public or open court, as unfortunately being done in this case. So you know what the Ghana Bar Association did? Instead of triggering Article 146, they rather issued a writ to achieve the same aim. Do you get it? Now, the reason for this important provision is obvious. It's to preserve, protect, safeguard the authority, dignity, and independence of the judiciary. It will be a sad day for this country if the court were to grant the request of the Plaintiff Association and start removing our judges in open court, contrary to the provisions made in the Constitution for that purpose. It is in the light of these observations that I consider this action of the Plaintiff Association, I mean the GBA, who should be expected to know better. Listen carefully. That an association, the creme de la creme, Lawyers Association, should know better. Most unfortunate, as is likely to undermine the judiciary in particular and the rule of law in general. The reason why I decided to go back to 1994 is to underscore what the judiciary, the Ghana Bar Association and its intervention over the period has been. I am not surprised at all. Look, when President Mahama decided to appoint 2 justices of the Supreme Court, His Lordship Justice Kwaman and Justice Yao Apao, again, the Ghana Bar Association took President Mahama to court. The association was almost quiet until the later end of President Akufo-Addo when they started speaking. Why so? With respect, what is it relative to these impeachment proceedings against a ladyship, the Chief Justice, that is untoward? That is a bad precedent. That has not been put out. Has any provision of the 1992 Constitution been undermined? No. I am looking forward. And look, thankfully, my good brother, the Supreme Court, even in this matter, has had the opportunity to intervene, either by describing an act unconstitutional or not, either to injunct a process or not. The Supreme Court has effectively agreed. Now, how come that an association of lawyers, with respect, appears to take a view? And when you say a bad precedent, I've been struggling, I've been struggling to understand what exactly is it that is bad. Because first of all, I am not the maker of the 1992 Constitution. I do not think the president of the Ghana Bar Association, President Mrs. Efuagati, is one of the framers of the Constitution. I do not know. But in the wisdom of the framers of the 1992 Constitution, they actually envisaged, saw into time, that there will be a day that a Chief Justice may be alleged to have misconducted herself and which will require a hearing. Are we, for any reason, saying that those provisions in the Constitution are bad? Is that the suggestion? Because if those provisions are in the Constitution and are being used, where is the bad precedent? With respect, once again, President Efuagati appreciate greatly that the position of the justices of the Superior Court and their removal processes by way of security of tenure applies with all necessary modification to independent constitutional bodies. So when President Mahama, having received a petition from Rachel Nyama, Frank Anodompre, led by way of counsel, Mr. Samson Ladi Ayenedi, for the removal of Mrs. Vivian Lamptey, Loretta Lamptey, the Shrad Board, an appointee of the NDC. Was it a bad precedent? Because in the same Article 146 that was used. And I remember when President Mahama received the petition, right, from Richard Nyama, what President Mahama did was to give it to her ladyship Georgina Wood, then Chief Justice, to make the prima facie determination. After she made the prima facie determination, her ladyship, Georgina Wood, then set up the Eniebua committee. It was my Lord Justice Eniebua, Justice Anthony Brennan, and her ladyship Mariama Owusu, to make an inquiry into the specific allegations against Loretta Vivian Lamptey. Eventually, the committee recommended her removal. Prior to the removal, in a release by the then Chief of Staff, Prosper Barney, in 2015, President Mahama suspended Loretta Lamptey. Suspended her. How different is that from what has happened today, 10 years after? Was it a bad precedent? As recent as I think 10 years ago, we saw President Nana Dankwa Akufo-Addo apply the same provisions of Article 146 in the removal of Madame or Mrs. Charlotte Osei, in the removal of Mrs. Amankwa and the late Amadou Sule. Was it a bad precedent? I mean, where from this sudden claim that a full compliance with the constitutional provision constitutes a bad precedent? When President Nana Dankwa Akufo-Addo removed the head of an independent constitutional body like the Electoral Commission, the bar never issued a statement. Please, unless of course the bar intervened and I'm not aware. If you know, please give me the benefit of knowing how the bar intervened when Madame Charlotte Osei was removed. I want to know. In fact, I recall vividly, and I'll say this. After the removal, Mr. Kweku Baku, the respected journalist in this country, went to the Supreme Court to say that the removal of Charlotte Osei on mere grounds of procurement breaches without no further evidence, either she has stolen public funds or not, the Supreme Court refused to entertain that process. In fact, the lawyer for Kweku Baku was my senior, Samson Ladi Ayenede. The Supreme Court resisted a writ action to challenge the removal of Madame Charlotte Osei. Was it a bad precedent? You see, the accounts have a saying. Yes, so way of one side. So way of one side. No, I share one side. You know of war. You know of war.
That's
the monkey.
Monkey. It's a monkey. Exactly. But that call, this call for the reconsideration of the suspension, if you listen to your president, your bar president, says that in the spirit of reconciliation, they're hoping, and he says we, essentially representing the position that you, the members of the Bar Association, have taken, that the various calls for the reconsideration of the Chief Justice suspension will not be ignored, especially given the poor precedents that is set.
You see, when President Mahama...
That's what he said.
No, when President Mahama suspended Loretta Lamptey, he gave a policy reason. And in fact, it was at the invitation of the petitioner. You know what they claim was? That as the head of SRAJ, the reason for the petition was or had to do with payments and others, because she was supposed to go to a resort residence, she didn't, she was in a hotel, all kinds of things. And they said, look, if she's still there, listen carefully, the possibility of evidence suppression, among other things, will be profound. Huge possibility. So President Mahama suspended Loretta Lamte. Was it a bad precedent? But you see, let me tell you something today. In the removal process of a ladyship, Gertrude Tokon, do you know that judicial service staffs are testifying before the proceedings?
Judicial service staff are testifying?
Yes.
Before the committee?
The committee, yes.
I see.
Imagine testifying against your boss. Can you, for want of a better example, the general manager of Media General.
No, you can use another example. No, I mean, just. I mean, let's use a different setting. But I get the point.
Let me use another example.